Hello, folks. It's Denise Howell here. And next up on TWiL, we've got tweeting lawyers, tweet law, Twitter beta testing a spine, and is OAuth going to murder your kids? Eric Johnson, Evan Brown, and Matt Macari are all going to help me decide about these things and more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 96, recorded January 28, 2011. Come together, y'all. This episode of This Week in Law is brought to you by MailRoute. Businesses of every size use MailRoute. 1 user, 50,000 users. It doesn't matter. MailRoute will protect you from spam and viruses, simplify your life, and make your email usable again. Please visit their site at mailroute.info to sign up. Hi, folks. You've tuned in for TWiL, and no, that is not some kind of wrinkle-free cotton fabric. It is This Week in Law, your every week destination for all things related to internet law and technology law. So here we are, back again this week. We've got Matt Macari, a patent lawyer and frequent Twitterer. Hi, Matt.
Hi, how's it going, Denise?
Great to have you. It's going really well. Love to have you back on the show. Have some patent stuff we want to get to today. Also joining us.
Appreciate it.
Yeah, wonderful to have your insights. Also joining us once again is Professor Eric E. Johnson, who teaches torts and intellectual property law at the University of North Dakota Law School. Hi, Professor
Hi, Denise.
Johnson.
Hi, Evan. Hello, everyone.
Hello.
Hey.
Great to have you back as well, Eric. And we've got Evan, whose mother was not a hamster. His dad smells nothing like elderberries, but he is a blogger and lawyer. He blogs at internetcases.com and practices law at Hinshaw and Culbertson in Chicago. Hello, Evan.
Hey, it's great to see you, and I'm sure that there's something that will trigger another Monty Python reference before the end of the show, because we're pretty good at working those in. So it's great to be here and looking forward to it.
Well, you're all tasked with that now, so
I don't know if I'll be able to think about much else. Everything's going to.
I caught it in reruns on the Independent Film Channel the other night. Have you guys ever watched that sort of random cable channel that's out there, IFC channel? Very, very good. Lots of comedy stuff. They've got the Onion News Network on there.
Oh, wow.
Which previously I'm only used to seeing online. They have jumped over to the television medium, and it's hysterical. I think it's every Friday.
A lot of that stuff's good, between 2:30 and 3 in the morning if you're ever awake. Some of those old independent films. I don't even know what I was watching, but there was some old Stallone movie from, probably the early 70s, mid 70s. It was like this race car themed movie long before Rocky or before Sylvester Stallone was anything. So that can be some really obscure and random stuff to kind of get you in the middle of the night mind frame for that stuff.
Right. They have great comedy stuff on there, too. They have Ben Stiller's original comedy show with Janine Garofalo. It must have been recorded in the 80s just based on the hairstyles and shoulder pads. Hysterical.
Oh, I did see that the other day.
Yeah,
it was, you tell it was early on for him, at least. It was
definitely. Speaking of early on, I have a question for Eric that has nothing to do with our links and points we hope to get to during the actual substance part of the show. But I was wondering, Eric, just reflecting on what it must be like to teach intellectual property law today, and specifically with a slant on technology and how technology has impacted intellectual property law. And I was thinking before the show, if I were to mention Napster to my kid or, even an older young adult, they would look at me with blank staring eyes and have no idea what I'm talking about, because it's so not part of their experience of the internet or technology. And it's also, I assume, not part of the conventional way that things are taught. Do you find Napster in textbooks? And how does the last 15 years of what has happened in business and technology come into folks' education?
Well, that's a good question, and Napster is in the case books. I skip it. I mean, it is so old, as you've said. It's just not really a live issue anymore.
Right.
It is. Those things are a challenge to teach in terms of the traditional way of teaching a law school class. I try to teach using some cease and desist letters. And some other things like that to go beyond the cases to get a feel for how intellectual property law works in terms of intimidation as well as in terms of verdicts and judgments.
Let's talk about Twitter. We didn't really talk about the fact that a bunch of Twitter users' data was subpoenaed recently by the U.S. government with respect to WikiLeaks. And what they were looking for was account information for each account associated with WikiLeaks, and even those who were following the WikiLeaks account on Twitter, which you can imagine was kind of a sweeping request for information. And there was a big uproar on the web when it happened. But what didn't get talked about so much was Twitter's response. And over at threat level, let me see, it was Ryan Singal who posted that he thought Twitter's response to WikiLeaks to that subpoena should be the industry standard, and came up with a turn of phrase that I just loved, which was that Twitter was beta testing a spine because rather than just letting all this unfold and turning over the information or not turning over the information, Twitter, and I think we probably have our friend and former TWiL panelist Alex McGilvery to thank for this. He's their chief counsel over there. They made a request to the court that they be able to notify the users and get the users involved, if they wanted to protest or object to or quash these subpoenas. And I wanted to toss that out there and just get your guys' thoughts on this. Matt, what do you think? Should this be the industry standard, as Ryan has suggested, and how do you go about enforcing something like that?
Well, I think it's great, actually. The issue doesn't really center so much around whether a subpoena should be issued. It's the gag order that came along with it,
right?
Which in effect kept people from being able, it basically put nobody out there to challenge it, other than Twitter. Mm-hmm. And so the problem comes in that you have a standard to meet in order to get this information. You've got no one out there, especially the users that are actually affected by the subpoena, there to be able to quash it. So they did the right thing, though. They went after the gag order, because the gag order allows the government to go after these documents or this information under the radar without any scrutiny at all. So I think it's a great thing. The unfortunate part is it puts it puts a burden and cost on Twitter, and any other service that has to deal with the same thing, because they have to, in some respect, go out there and challenge these things, if nothing else, just to get the gag order lifted, so that they could actually permit the users to understand, have noticed that this is occurring, so that they can challenge or quash them.
Right. Evan, have you ever been involved in a subpoena that had a gag order, and was that an issue? And what do you think of Twitter's approach here?
Yes, I have been involved in situations akin to this, where there is a gag order is such an evocative way of talking about this. It's really just two sentences in the order that says, don't tell anyone, don't notify the targets of this investigation. So. Yes, I've been in this. I mean, when I've been advising companies who serve in an intermediary role, like what Twitter was doing here, custodians, stewards over this personally identifiable information and account information, we've of course always complied with those and have not gone to the expense of challenging those. And Matt, raises that point there. It really is a burden. It was a burden on Twitter to do this, and I suspect that it's just pure economics and financial realities and the corporate budget that stop a lot of companies from doing this. But in addition to all of this, I think we need to not be too quick to assume that in every situation where there is a gag order, we'll just continue calling it that, this provision that says don't tell anyone about it, that we can't be too quick to assume that in every situation where there is something like that, that provision doesn't belong there. I mean, after all, there are a lot of legitimate criminal investigations that go on, and I would like to think that the majority of criminal investigations are actually pursuing the real criminals and not the wrong people. So clearly there are plenty of reasons all the way down from national security to the individual safety of people. Their personal well-being and the safety of their person and their family depends on the integrity of these criminal investigations. So I don't know that I would go so far as to say what Twitter did should be the industry standard, unless what we mean by that is saying that the industry standard should be companies should, in every instance, make a reasonable investigation of their own as to what's going on here, try to make a principled determination as to whether this gag order should be challenged because of the predominant First Amendment interests, for example, that I suppose that Twitter had, for this WikiLeaks situation. We could ask Alex sometime if we're talking to him, though I doubt he would answer us.
Yeah, probably not. He wasn't there.
Wasn't even talking to Wired.
Yeah, I think Ryan Single tried to get him for comment and he declined.
So we've just got to be careful. It's dangerous in every instance to speak unequivocally as to what the standard should be. If we're smart, we've got to realize that there's nuance in everything. Kind of happy to see that Twitter did it in this situation, but let's not get carried away with this.
Well, I have a question on that, and I haven't practiced in this area, so I'm not really sure how this transpires. But should there be, if there's not, some initial burden or threshold that has to be met before this type of language or gag order or whatever we want to call it is put onto a subpoena, rather than just having just some stock language that they could throw on there without any requirement of a showing of cause or whatever standard it might be?
Well, the court has to bless it, right, Evan?
Yes, so there has to be a threshold finding of probable cause in the first instance, because this technically is not a warrant, but it's akin to that. This is actually coming to us from the provision of the Stored Communications Act. Is this D letter, I think is what they call it, or D order, what they call it here, that Twitter was dealing with here. So there's a certain threshold finding that this investigation has some merit. So then it's usually tacked on there at the end, this extra protective measure that the law enforcement angle of it sees the danger of evidence being destroyed or done away with, or suspects fleeing or otherwise concealing themselves if they know that they are the target of these things. And I mean, this is an easy situation. WikiLeaks one is an easy situation to criticize a gag order because, it's WikiLeaks, and it's right. that the issue is so polarizing. If this was child pornography or, Al-Qaeda or, a Ponzi scheme, or, somebody really doing some harm here, we wouldn't be talking about this at all. We're not talking about it at all. All the hundreds of gag orders that are issued probably every week in situations like that. And nobody's going to sit here and say that a child pornographer should get the protections of having the opportunity to run and hide when he knows that the feds are after him.
I'm kind of thinking, Evan, that even in the situations that you're discussing, if we're talking about account information, stuff you would not ordinarily fork over to the government unless you were subpoenaed to do so or ordered to do so by a court. Should the fact that it's with a third party really mean that the government can get at it secretly?
It's kind of, yeah. I mean, it's going to just depend. I mean, I don't know how we could possibly, draw bright lines on this because of the fact that, what's pitted against one another is this what I think you're hinting at is this sense of autonomy that we aren't really willing to give up, or at least we think that we're not giving up when we are allowing ourselves to be identified based on information that technically is not within our custody and control, but is within our custody and control only by means of a legal fiction, which is your relationship with the service provider that is brought about from you having clicked on the I agree button on the terms of service. So it's that personal sense of autonomy and wanting to hold on to privacy, even though everything is happening on this layer up here on the internet, against the important interest of law enforcement, which, regardless of how much disdain we carry around with us, stressing us out, for the government, I still want the government investigating crimes and making sure that my family and I are safe from those who will do us harm.
Sure. Eric, I think we can hear you once again. You want to chime in on Twitter's response to the subpoenas about user data related to WikiLeaks?
Yeah, and you can hear me now, right?
We can.
Yes.
Very good. Okay. So I really applaud Twitter. I think what Twitter did was great, and I echo Evan's comments. It's a tough area. I'm not sure that it's necessarily so unique to the online context. The one thing that I would like to add is just that I think WikiLeaks is despicable. I know there's a lot of talk about how wonderful all this stuff is. The first time I went on WikiLeaks, before this whole thing happened, what I found on there was, I recall the first document I found was a maintenance manual for a military aircraft engine. And there's just no public good that comes out of that. I mean, if that's going to be useful to anyone, it's going to be useful to people who are trying to kill Americans who are trying to protect the country. So I think what Twitter did was fantastic and meant a lot. But at the same time, there's some real criminal wrongdoing at the heart of this. And while I think a gag order in this case was silly, I don't begrudge the government the seriousness with which they're treating the investigation.
So we were talking about Napster a little while ago, and the fact that I was interested in how you educate folks in your role as an educator about the history of the web over the last 15 years, since it's not really, I don't know, I'm not a teacher, so perhaps it is the subject of textbook and professorial dissertation and et cetera. But going back to that, just as it was impossible to sort of squelch the dark net then, I think it's impossible to squelch it now that, this genie is out of the bottle and people see that there is this, huge market and thirst for knowledge and information that is just going to get out there. On Twit this last week, they were talking about the Swiss bank account information that's now being vetted by WikiLeaks, and I'm not sure if they've actually put it up there yet or not. But that's a different kind of shade of information that previously was private, but certainly is a lot of interest in seeing who out there, what public leaders and servants worldwide are utilizing the Swiss banking system to mask some of their activities, and that kind of thing, is subject to its own criminal gloss. I mean, maybe the leaking of the information certainly has some issues around it, but the actual activities that are underway that are learned about through that information do as well. So it's sort of a long way of asking, how do you stop something like this? I don't think you do.
You can't. And in terms of privacy, I think not only do I have to constantly put the technology in context for my students and talk about what the web was like 15 years ago when you'd go onto a website and it'd say press Netscape or press Internet Explorer for your preferred experience. Mm-hmm. But also, you remember that, but also we have to put expectations of privacy in context, because there's just a huge generational difference between how older people feel about having facts about them exposed online, made public for everyone, and how younger people feel about it. I mean, there's just younger people are just not troubled by it. And I think a big part of how all this internet privacy, all these internet privacy issues are going to come out in the wash, it awaits determination when we have when the current young generation of people who grew up with Facebook in high school grow up to assume positions of power or sitting judges and legislators, and we find out how they deal with privacy in coming from a group of people who've just always been in one another's business and just are less sensitized to those issues.
Yeah. Our IRC chat room is going off on the notion of the public availability of knowledge of military aircraft engines. Eric Duckman there says there's a guy here who owns a MiG-17. Well, actually, technically, he owns part of it too. Long story. But yeah, I can imagine that, yes, for things that are capable of public ownership, a different standard might apply than to things that actually are flying about. And
what I'd like to see WikiLeaks do is leak some corporate documents. I'd love to have some good contracts that are secret contracts to talk about in my entertainment media class. Corporate America is a lot more closed off than the government. The government has, FOIA, which requires some documents to be produced upon request. So even though I've just slammed WikiLeaks, if they're going to be doing this, I'd like them to leak some corporate things, especially from the entertainment industry. That would be my personal request.
Okay. Well, hopefully Mr. Assange is listening, and we'll try and oblige you. Now, let's talk about FOIA for a minute. We have a story about that as well. Not technically FOIA, but the California equivalent. And actually, let's see. It's not California. It is, what state are we in here?
City of Charlotte, is it North Carolina?
Yeah, actually, there was something in California that happened similarly to this. And what's happening in all these places is there are information requests, Freedom of Information Act type requests to government agencies that have data on people because they are operating online, and people can go in and put in their personal data, email, etc., to be able to perform their government services functions, whether you're paying bills or checking on something that relates to your home, whatever you're doing, you have an online relationship with your government, and they have some of your information. And what's been happening is that private entities have been using these Freedom of Information Act type laws to get at that information. And use it in this particular sense to send out a mass mailing from a newspaper here, sort of in a survey type capacity. So that's an interesting little twist. I mean, obviously, it seems like this is something that needs to be tweaked and adjusted, where the law is overbroad and didn't anticipate that all public information might not be the kind of thing that should be disclosable upon request. Evan, what do you think about this one?
Yeah, I have to believe that some form of this issue has to have arisen before, even before email addresses and stuff like that. I mean, the government has maintained records that's personally identifiable of its citizenry for a long time. I think it was the 1830 census that they first actually started collecting people's names when they went around instead of just counting everybody. So, there's got to be something going on there. And at the same time, I'm no expert on FOIA or, it's most of its state and local equivalents, but I know that a lot of folks in my firm here, we represent a lot of municipalities and government entities, and so by osmosis, I have learned that these Freedom of Information Acts are not limitless. There are well-defined categories of information that's not subject to public disclosure for a number of reasons, and among those would be the integrity of a person's personal information, personal identifiable information. So I don't know why it would be too much of a stretch for us to make some exception here or some constraint on these to protect the spamminess of the things that result from these activities. It's amazing how much time people have on their hands, I guess. It just seems like it seems like a really burdensome way. It'd really be dull to just gather that stuff from the government.
It would, but I guess the payoff would be kind of impressive if you're in the marketing industry, for example. Eric, what do you think about this? Obviously, there's tons of very, very personal information that the government has about us, our tax returns, et cetera, and those are protected from disclosure. Shouldn't our, account information with municipalities be treated similarly?
Yeah, I think it should be, and I think this is a screw up with South Carolina or Charlotte's law with their version of the FOIA law. I'd like to make a couple points about this. First of all, the Charlotte Observer editor wants you to know he's not going to use it for spam, just to send you a friendly email invitation asking if you'd like to occasionally invite. That's spam.
Yeah.
That's spam, Rick.
Yes.
So just wanted to tell you that. And but it's actually nothing new that private companies are using FOIA for commercial interests. I think that most of the FOIA requests, and I'm making an educated guess here, but I think that most of the FOIA requests that the government gets are probably commercially interested FOIA requests, particularly FOIA requests seeking government contracts so that companies can get pricing information and valuation information. So I think that's been very common for a long time. Here, what's new is that a newspaper's doing it rather than a defense contractor or some big multinational manufacturer of something. And we're used to thinking of newspapers as acting in the community interest and being custodians of the public trust. But as the newspaper industry has been under threat, we've seen that eroding in more than one way. For instance, with Right Haven and their suits against readers and bloggers over copyright infringement.
Yeah, Socrates in IRC is saying the trajectory of the amount of information that the government has collected on the citizens of the country has gone from minimal to Orwellian. Matt, any thoughts on this?
No, I think it's all been said. I think that I agree with Evan that I think the FOIA guidelines, it doesn't give you a blank check to just grab all documents. Matter of fact, anybody that's tried to obtain documents through FOIA knows that it can sometimes be difficult. So I do think it was a situation here where perhaps a municipality that wasn't used to dealing with it under the current laws maybe got carried away and didn't proceed accordingly. That would be my guess.
Well, speaking of spam, everyone remembers Beacon?
Yeah.
So this week, Facebook released sponsored stories where folks now are finding that their information, their things that they have chosen to engage in on Facebook are being used in a commercial way once again, and folks are up in arms about it. Is this just Beacon, the sequel, or is this slightly different? What do you think, Eric?
Well, let me just stay here unequivocally, make a prediction. 5 years from now, Facebook will be dead.
Okay.
No one, it will be like here. MySpace. I think Facebook is headed straight into the toilet. It has become uncool. And, that's the theme of the social network is we have to make it cool and not worry about the money. I don't, the Facebook that you see in the social network movie is not the Facebook that you see today. It will either have to change radically or it will be replaced by something else. This is so absurd. We have a whole law called the right of publicity, which prevents people from doing this, from taking your name, your image, your story, and using it as part of an advertisement. Now, I assume that the lawyers at Facebook have been smart enough to put some language into their terms of use, but it's absolutely irritating and legally, if they can probably take care of it with terms of use, but this is going to kill them. I just think they're going down.
Wow. Okay. So there's one extreme of what might happen with this trend. The other extreme, I guess, would be that people just don't care. Transparency. I'm using something, and I really don't care if you tell the world about it and let the manufacturer or service provider benefit from it. Evan, do you think people care?
Well, this isn't quite as bad as what Beacon was, I don't think? Because it seemed to me that as far as I understood Beacon, I mean, I didn't develop a real granular knowledge of it because I, didn't want to be a part of it. Mm-hmm. That seemed to be your use of your name, image, persona outside of the context of where you actually were, metaphorically speaking, on the social networking platform. So people would see stuff about you and get this information about stuff you like and what you were doing and all stuff you'd bought in Beacon. And so you wouldn't necessarily know where that was happening. With the sponsored stories here, at least you'll be able to see where that is. And I hope that I'm understanding it correctly, how it's actually going to work, because I haven't seen it rolled out. Is it rolled out yet, or is it just something that people are talking about, or is it rolled out on a limited basis? But whatever. My impression of it is that it's much more confined there. So in my view, it's just a continuation of the trend that has been going on since 2006, which was shortly, relatively speaking, after Facebook was made available to those of us who were not using a .edu email address to sign up, when it first truly was made available on a public level with the news feed. I mean, we forget that there was ink spilled and pixels displaced in a big brouhaha over the fact that there was a news feed. I mean, good grief, that's the most fundamental function of Facebook now. I mean, can you imagine logging onto Facebook and not checking to see what's going on? People thought that was just absolutely atrocious in 2006 when that was launched. So we just see a little bit of a progression, if you want to characterize it as an erosion on the whole experience, or some kind of corrosion of your experience on all this. We can characterize it that way, but looking at it objectively, it's just a trend that continues in that direction. And so will it cause the demise of Facebook, as what Eric is suggesting? I suppose that it might. A critical component of that is going to be a suitable replacement for Facebook, especially one that's easy to just, if everyone can port their information over from Facebook to some other platform in short order, that will help Facebook's demise. Just because MySpace wouldn't have died if it wasn't for Facebook. Can't we agree on that?
I was going to say MySpace.
Somebody on the panel or in IRC remind my addled brain of the project the NYU students are doing that we talked about before on the show.
Diaspora.
Had their supervisor on the show.
Diaspora.
Diaspora, yes. So
yeah, that's a great idea, but I mean, I'm just trying to think of an archetypal example of the people who are on Facebook. It requires a lot of savvy to really get the most out of diaspora. Is the boomer demographic and above going to really be interested in that, in doing something as like diaspora, and even the in any demographic, the technologically unsophisticated, are they going to want to do something like that?
Yeah, this strikes me, and I think it is rolled out, Evan. I haven't actually seen it impacting my own Facebook page, so I don't know if it is rolled out across the board. But I believe it's out there. Somebody correct me if I'm wrong, and they're just sort of floating a thought balloon on it right now. But it reminds me of the way Gmail operates, that it's paying attention to the discussions and conversations that are going on, as it sees something that is relevant. If they're partnered with something that might slot into your discussion and prompt a purchase or an action on your part, they slot it in and they tag it as a sponsored story. So I think that, from that standpoint, as long as folks are aware that it's happening, and, as Eric said, from a legal standpoint, they can probably cover themselves. But, once they start sticking ads all over everything, it is going to become an uncool place to transact your information and communications with people. What do you think, Matt?
Yeah, I think I look at this differently than a lot of people I know, including my wife, family, and friends. I hate it. I came up on Facebook quite late. I probably in the last year, and I already hate using it. And
okay.
And I use it I post some pictures of family, things like that, just to keep people kind of keep in touch to some extent. But I do not go on it regularly anymore. Mm-hmm. And the biggest thing for me, and I see the differences here, because my wife could care less about the ads, care less about some of the apps and the various things that I find very intrusive. And I'm not necessarily a paranoid privacy guy. I just find it annoying generally, and I'd rather ignore it and not use it, and use something like a Twitter where I feel like I can control what's coming to me a little bit better and what's going out. And that's just that, and I think until the kind of mainstream, the people that use it and don't care so much, actually it becomes more intrusive to them and more annoying, then I think they might be around for quite a while. And there's going to be some adaptations when it crosses that line. I think they're going to have to make some changes in order to, at least if they're going to survive, to bring it back to where people can tolerate it.
Mm-hmm. Well, since Eric writes a lot about blog law and things that touch the web in general in that fashion, I do want to get to talking about this woman who was fired over Facebook and the impact that her case may have on the way that companies treat people's online communications. But since we've been talking about spam, before we get to that, I do want to take a moment to thank our sponsor, MailRoute, and thank them, too, for eliminating so much spam from people's lives. None of us like it, and MailRoute is helping to keep yours at a minimum. Businesses of every size use MailRoute. It doesn't matter if you have 1 user or 50,000 users. MailRoute will protect you from spam and viruses. It'll simplify your life and make your email usable again. Woo, thank goodness. So what it is a secure hosted service that filters viruses and spam for companies of any size, and it'll do it for individuals too. Whether you're a single user or a company with tens of thousands of employees, it can eliminate all the viruses and spam that you would see in your email otherwise. It'll reduce the load on your own email server because they're going to process that on their end. It'll lower your costs, and it will, once again, make your email usable. Typical MailRoute customers see a 95% reduction in their inbound email volume with virtually no false positives. So this stuff really, really works. And because it works, Leo uses it, Tom Merritt uses it. They've had domains that they've had, receiving and sending email for years and years. Tom actually had to resurrect his old email address. And once he hooked it up to MailRoute, he had abandoned it because it was getting too much spam. But MailRoute solved his problem, and now he can use it again, which I'm sure makes him very happy. Tom had lots of good ideas that he couldn't stand to see go to waste, so he started using MailRoute, his next generation service for filtering email with a level of accuracy and a price that's unmatchable. So please go to mailroute.info to sign up. And as a TWiL listener, you'll get 10% off the life of your account. Small business accounts start at $2 per user per month for 10 users. And because you guys all listening have put such a great demand out there that you want to be able to use this on your own personal email accounts, MailRoute has added a new service for individual users, less than $30 a year for single users. Visit mailroute.info and sign up with the email filtering service that Tom and Leo use and love. Thanks so much, MailRoute, for sponsoring the show. All right, so let's talk about this Facebook firing. The hearing on this was postponed. They're supposedly in settlement talks. But what it means is we could see a closer look and an impact on the way that company blogging and other online communications policies are drafted. Because this woman was fired, she ran afoul of her company's policy. And the NLRB, National Labor Relations Board, is alleging that she was illegally fired because she was engaged in what could be considered organizing activities from a labor standpoint. So, Eric, what do you think of all this? Are we going to see some changes, or is the settlement of this case going to make the issue fall off the map?
No, I don't think the issue will fall off the map. I hope it doesn't settle. As a law professor, I never like to see things settle.
Right.
But, one of the articles you pointed us to has a quote from an attorney who says, this is a perfect instance of the law not keeping up with technology. I couldn't disagree with that more. I think that this really has very little to do with technology, and this is a very basic tenet of labor law. The idea of labor law is that without specific regulations about how much people should be paid and how employees should be treated, we can have employees bargain for good treatment and good wages if we protect their ability to organize. And part of protecting their ability to organize means protecting their ability to gripe to one another. And this is just another forum for griping. And it's absolutely a fundamental idea, fundamental concept of labor law that employees are able to get together and trash talk their employer. That's what allows employees to gel and to form those personal connections that leads to organization, which leads to organized labor. And even if that doesn't happen, the mere fact that it can happen serves as a check on employers to get them to treat their employees better. So what I think we see here is an overzealous supervisor who probably has no concept of labor law, didn't think that labor law had any bearing on the situation, and screwed up. I think it's an open and shut case. This was illegal, and they're going to have to come close to surrendering everything in order to get a settlement from the NLRB, based on the facts as I understand them.
Right. Evan, what do you think? Is this cyberspace exceptionalism here, or is there some reason to think about this differently because people's online communications are enduring and searchable and discoverable in a way their water cooler chats are not?
Well, first of all, isn't it great to have Eric on the show, because he'll tell you how it is. You know, what a relief to have an unequivocal take on something. I suppose that you asked about cyberspace exceptionalism and whether or not this should be treated differently than, you know, kind of typical water cooler conversation because it's on the web and all that stuff. And, you know, my default setting is to think that cyberspace exceptionalism, approaching it that way, thinking that the law should give it special treatment just because it's on the web, is in general not the right way to approach things. There are a very limited set of situations where cyberspace exceptionalism is the right way to proceed into the future. You know, like Section 230 and the immunity for online service providers is a thin example of where cyberspace exceptionalism is good. You should treat publishers different because of the it's special being on the web because there's all these billions of bits of, or you know, all these billions of different items of content that go across the web every day. With this one, the only way, or the only reason that there should be any kind of special treatment on this is looking at the effect that these types of communications can have in the ways that they can magnify the effect of the ordinary type of communications that they truly are. That was a really convoluted thing I just said, so let me try to give it some explanation. You have this type of content, this category of content that we're talking about here, and that is concerted activity, as that term is defined under the labor laws. It's the things that you do with your coworkers to say, the man is holding us down, let's join together so the man can't hold us down so much. That's, right. Concerted activity. You do that by, historically, going back a few decades, handing out pamphlets, assembling together, for meetings, joining up and hiring lawyers to represent you as a union interest or as a labor interest. Those things are prima facie, or I guess per se is actually the words I'm looking for. Examples of concerted activity. Here, it becomes much more of a gray area because of the ways that it's done and the effect that it can have in terms of who actually sees this stuff and how you can communicate with it. You put it on Facebook. Facebook, by its nature, is meant to facilitate this type of collaborative communication and all this stuff. And it's, that's really close in nature just inherently to concerted activity here. One other complicating factor on all of this, and this weighs into that whole situation from Connecticut in front of the National Labor Relations Board, is there's this overlap between use of these tools in the workplace and use of these tools at home. One of the things that's going on in this case is also a criticism of the reaching policy of the employer in prohibiting
what
this
you do
stuff.
on your own time is your own business with your own equipment, etc.
Yes.
And we have a question that actually I want to jump in and get answered before we go further with this from Kitani Yatsu, I believe, in IRC, just asking the fundamental question that maybe the supervisor was unaware of too, Eric, of whether you're permitted to gripe on company time and using company equipment, etc. That goes to the heart of this case. And under the labor laws, that's one of those exceptions where I think, despite what a company policy might say, that yes, indeed you are. And this is something that's been fought and won on the labor front. Am I correct about that?
Well, I don't know. I'm not a labor lawyer, so
Yeah,
I can't get that detailed. But the law is very solicitous of that kind of activity. So yeah. I can say that as a general matter. I really, as a specific like that, I don't know where the line would be drawn.
Right.
You can't stop the assembly line to gripe about your boss. I mean.
Right. But, if you're, in the, I used the water cooler analogy. I think if you're in the break room and not on duty and, but again, using company equipment starts to complicate things again. And there are all kinds of restrictions in policies now on what you can and cannot do on your company-issued computer. So that's an interesting twist on this, too.
I have a question. Labor law couldn't be much further from my day-to-day practice, but the first thing I think of is somebody that, maybe had a chapter in my employment law course in law school on labor law. I don't recall the interplay between the NLRB and the typical what we consider at-will employment, and the fact that you can obviously they butt up against each other and they maybe offset each other quite a bit, but I guess that the question you got in the chat is the question I would have, just as somebody who doesn't practice in this area, is what can you do then? What can you get away with as the employee, I guess is a way to word it, before they're permitted to terminate you.
Yep. Well, we can get our labor lawyers back on the show to address some of those more labor-intensive questions. I don't think any of us are qualified to give definitive answers on it, unfortunately. And here we were praising Eric for his ability to cut to the chase.
Well, until he said that, he had me fooled. I sure thought he was a labor lawyer.
So we'll get back to you on that one.
This case was on a personal computer, and it was Facebook, which, as Evan said, is where people come together. I think this case is open and shut. Right.
Exactly. So we'll have to see. When someone's doing company organizing, setting up a forum, maybe not on the company's website, but using the company's computers and emailing. I think the question of emailing people at their work email has come up in these cases before, and that kind of thing has been protected as, yes, you're able to, conduct your organizing activities in that environment. But again, not my area of expertise. Let's get to something that is more in our wheelhouse, guys. And let's talk about patents, Matt, your particular wheelhouse. A couple of interesting things going on. Let's see. We've got one of our listeners sent me an interesting story in the New York Times about computer code being an increasingly precious commodity in vehicles, in electric vehicles, and how these things are starting to be much more computer than car in a lot of ways. And so that starts to make the IP within them very valuable. Of course, car IP, I guess, has been valuable all along. Do you want to elaborate on this for us a bit?
No, I don't think there's too much controversy in this article. It's, the fact is that, software, hardware and software interaction, those types of things have been increasingly more important on the IP front and the patent front for years. And I guess I don't see anything controversial about the fact that, that that these companies, when they're dealing with this technology and these electric vehicles, that this is something that they're focusing on as kind of the future and what they want to protect. So this particular article didn't cause me much pause. The other one, on the other hand, caused me some pause.
The one about innovation versus invention. Okay,
Yes.
let's talk about that. Give us the context on it first. Well,
I know that attorneys say this a lot, and they don't mean it, and they say they're confused by certain things, but I'm a bit confused by this article. And I get the gist of it. It's that basically monopolies can be bad for innovation, in that at some point they feel like there's a pinnacle of invention. Therefore, anything that occurs after that point shouldn't be patentable, shouldn't gain a monopoly in the marketplace, and should be permitted to others should be able to improve upon it without the burden of the patent system, and namely the patent holders that acquired the initial pioneering type invention. That's the gist I get out of it. The problem I see with it is that it assumes some things that don't really mesh well with patent law. And the first thing is that somehow to qualify as an inventive right, it has to be something that is pioneering or reaches the pinnacle of the invention, or something that, so under that theory, we're going to have patents on the wheel, the microprocessor. I mean, it's going to be limited. And I think it's been recognized, it has been recognized since day one in the patent system that these non-obvious improvements that occur along the way are just as patentable. And I don't see the issue being with that limiting innovation, other than if it's wrongly obtained, the patent. And that's an interesting part of this article, because a lot of this focuses on a couple of anecdotal stories, Thomas Edison and
this is Mike Masnick's article, by the way, over at TWiL.
Yeah, so I mean, the idea is, okay, well, you get these patents through wrongfully, and they're somehow assuming that these patents from Alexander Bell and Thomas Edison were wrongly obtained. And then what it does is it stifles innovation. And that if you just had this kind of monumental pioneering, basically if you allowed patents on these pioneering features or pioneering inventions, then everybody else should be able to kind of proceed with innovating on those, because the assumption there from the author of this article is that it is obvious that whatever innovations or improvements are made upon those pioneering patents are obvious, and that's just not the way it works. It's not the way I found it to work. So I guess I have some fundamental disagreement with kind of the background concept or the assumptions that are made in the article.
How about you, Eric, in your capacity as educator on intellectual property issues? Do you think that it's important to make a distinction between innovation and invention? And how broken are you telling your students the patent system is?
Well, two very good questions. First of all, I just completely disagree with saying that innovation is the one thing that they say it is and invention's the other thing. Here, I'll read the quote. It's invention is turning money into ideas. Innovation is turning ideas into money. Just because we've all read these things, but for people watching, invention is the process of coming up with something new. Innovation is taking that something new and successfully bringing it to market in a way that people want. I just don't think that's true. I don't think that's how people use the terms, and it's sort of an artificial distinction. I mean, someone can wish that the terms meant those two specific things. I don't think they do. They're much closer to being synonyms. In terms of whether such a distinction makes sense in terms of the patent system, I'm really with Matt on that. I don't think that distinction is very meaningful. I'm a skeptic of much of the extent of the patent system. I just finished a draft paper saying that the core economic idea that invention or innovation, or if you want to use the Disney term, intervention, whatever it is, that it needs an outside economic incentive, that whole idea, I think, is probably wrong as a general matter. So I'm a skeptic. But that being said, to the extent that there's a problem with the patent system, this does not go to what that is. I think that I think we should look at distinctions between industries. pharmaceutical industry versus the electronics industry versus mechanical inventions. There's some useful distinctions there in terms of whether the patent system is really serving as an incentive. But no, I don't buy it.
Okay. Evan, any thoughts on this one?
Well, I'm not a patent lawyer, so in large part, I come to the applicability of these notions to patent law as an outsider, but I certainly do practice intellectual property law. Copyright law is the closest thing, at least constitutionally, to patent law because it comes from the same part of the Constitution there. So, my view on this is that we can't lose sight of what it means for the protections of intellectual property to promote the progress. That's what the Constitution says, to promote the progress of the arts and the science and useful arts, people have patent rights and copyright rights. And so that's a wonderfully ambiguous at best notion, more likely just plain out vague what it means to promote the progress. Does that mean that we have to look at promoting economic progress, or does that mean that we just have to promote progress terms purely in terms of utilitarian progress, the greatest good for the greatest number of people? It could be that the greatest good for the greatest number of people is synonymous, or at least coterminous, or at least largely overlaps with economic progress. Those two things are certainly not mutually exclusive. And so it would just be nice if we could get some kind of consensus on all of these things, unaffected by a particular view of incumbency, by saying that, well, I'm from Disney, so I've got to see this a certain way, or right. I'm with the EFF, so I've got to see the world purely in terms of the public interest and not in terms of anybody actually making money off of this stuff. We've got to just somehow be reasonable in all this. President Obama should have made it part of the State of the Union. Why couldn't he have wasted or spent some time on that? That's how we need to come together, y'all.
There you go.
I'll add one more thing.
Go ahead.
Okay, one more thing I was going to add is, and I think a lot of the disdain that comes or is directed towards the patent system has less to do with whether or not they think certain things conceptually within the law are patentable. It's more about how it's executed at the patent office, whether things are examined properly, and how they're enforceable or how they're rendered enforceable after they issue. I know Eric was on here a few weeks back, and there was a great conversation about that, and the presumption of validity and how that might affect the weight of a patent, or how it's abused in many cases, or trolled. And I think those are the issues that really will get to resolving some of the problems, not so much about whether or not something's patentable only because it's pioneering and innovation is hurt by these improvement patents and things like that. I think has to be directed to the examination process at the patent office, whether it's dividing up the different arts and understanding the differences between mechanical, chemical, electrical, and things like that. And then maybe some presumption issues and enforcement issues or challenges to issued patents that can occur after the fact.
Well, we've been dancing around the issue here of what is patentable. We previously on the show a bunch of times have talked about what is copyrightable in terms of Twitter. And right before the show today, as I was jumping back and forth between Twitter accounts, I found myself on the Twitter homepage where they're just scrolling down things as they get posted. And I chanced to find the account Very Short Story by someone named Sean Hill. He has 68,540 followers. And they're tiny 140-character story tweets. His most recent one, the one that I saw as I was getting ready for the show, is I watched you walk by in your high heels and short skirt. My friends whistled, but all I could think about was when you used to be my dad. So, game over. That's got to be copyrightable, don't you think, Evan?
Yeah, that beats Hemingway. I mean, didn't he have the penchant for sitting around writing, coming up with 6-word stories? Jonathan Fields, I think, a blogger that I read, I think it was him. I'm giving a shout out to Jonathan Fields anyway, wrote something about that, and Hemingway challenged a friend to tell a better story in just 6 words, and I think Hemingway won that contest as something like baby shoes for sale, never worn. You know, there's so much.
I remember that. Yeah,
so much in that story right there, just in six words. So yeah.
Right.
Well, I know when I first started using Twitter, I think that was one of my first tweets. Was until you use it, I mean, I immediately thought, this is great. I'm glad it's not more than 140 words because characters. 140 words, that'd be incredible. 140 characters, because I just love the idea that people are forced to, even though sometimes it becomes you need a secret decoding ring to figure out some of the stuff that comes through because they use all the abbreviations and everything, the acronyms. But if you're just sitting down and writing it, I think it's a great exercise in just getting to the point. And so that it's a great thing. That's one of the reasons I much prefer Twitter over something like a Facebook.
Well, we have a law professor at our disposal. What do you think, Eric? Copyrightable, not copyrightable?
Well, there's an interesting doctrinal question here. Certainly, I would say it's absolutely copyrightable right off the bat. But there's a question in copyright law if there's only so many ways to express something. So you can copyright expression, but if there's only like 2 ways to express something and they've both been used, then other people have to be able to express it. So if they express it in the same language, then they get a pass from copyright law. So like that story, you can get a copyright on that expression of the story, but someone else should be able to use the idea for the story. The question is whether you can use the idea for the story in 140 characters or less without copying the expression. Now that we've talked about this, I won't be able to use it as an exam question. But wow, fascinating. Fascinating question.
Oh, sure. Your students don't listen to our show, do they?
Oh,
Maybe they
I'm
will
sure
when
they
you're
do.
on. And take close notes.
Gotta give them extra credit.
They will. Yes, exactly. All right. Well, let's get on to, since we're talking about some humorous things, I have a couple of resources of the week because one of them is really not that much of a resource. It's just kind of funny. 15 of the most bizarre laws that are still on the books. This is from the Criminal Justice Degrees Guide, and I guess this is their way of promoting their guide to criminal justice law. And let's see, they say browsing lists of outdated laws and statutes can feel a bit like reading The Onion. And so they've given us 15 of these really ridiculous laws that you hear about from time to time. You may not sound your horn in Little Rock, Arkansas, at any place where cold drinks or sandwiches are served after 9 p.m. Can't do it. And various others of that ilk. Always fun to look at these things that are still law, but perhaps are not so much being enforced these days. So thank you, Criminal Justice Degrees Guide. And for the link, folks, you can go to delicious.com/thisweekinlaw/96. And we've got it for you there. Did you guys take a look at this? What was your favorite, most bizarre law that's still on the books, Evan?
The prohibition in Kentucky of carrying a concealed firearm that's more than 6 feet long. Pretty good.
Yeah, that one's good.
And the second place for me was evidently in Wyoming. You can't solve any simple problems because, by extension, you can't shoot fish in a barrel. You can't shoot any kind of fish in Wyoming. That just, that totally takes away all the mystique of fly fishing, I guess. So.
Exactly. Anything here eye-opening for you, Eric?
I'm not sure that any of these are bizarre or dumb. I'm actually going to stand up for these laws. That doesn't mean I support them all. Now, the 6
You're
foot...
just a public policy guy. There's a public policy for everything.
Well, let's take a look at that law about not being able to honk your horn. So I actually looked this up, Little Rock, Arkansas. You can see that this not being able to honk your horn at that time around a place where sandwiches is served was passed in 1961 along the same time as a bunch of other laws that were clearly to stop cruising. You know, those young people in their 57 Chevys, that a whole American graffiti type of scene. So, I don't necessarily agree with it, but it's not wildly crazy. I mean, it's not like someone just went wow all over the ordinance books. Now, the 6 foot thing, some of these they have links to the ordinances. Other ones, they have links to another site that is like dumblaws.com or something like that, and they themselves don't have any links to the statute. So some of them are difficult to confirm.
You think urban legend may be at work here?
I think some of them may be. The Kentucky one, I should track that down because that truly sounds stupid. But other ones, not necessarily totally crazy. I'm not saying I agree with them, but not just absurd.
All right.
I had
go ahead, Matt.
It's driving me. I spent about a half hour before the show. I had a book that somebody gave me after I graduated from law school. It was an entire book devoted to this type of thing.
Mm-hmm. You could write a book on this type of thing.
Oh, some of the much crazier than this even. Don't eat pork chops on Wednesday. I mean, just random weird things. And some of them, dealing with some of the most common ones you see dealing with adultery and the punishments that go along with it. And, a lot of it's dealing with religious background and they come through quite absurd now. At the time, maybe they seemed a little more status quo. But, it's, in the end, they're dead letters, right? And dead letter law and will never be used and never challenged, most likely.
All right. Well, speaking of absurd, over at Read Write Web, Marshall Kirkpatrick has a great post on privacy policies being absurd. And he is writing about Fran Meyer, president of privacy auditing firm trustee, who's been around forever, saying that privacy policies are dead, and what we really need to be doing, and I think we've danced around this issue on the show a lot, is making sure that people understand what each and every transaction entails as far as they're sacrificing privacy or protecting it. I think that's the crux of what Fran is driving at here. And just, attempting to deal with that by putting a bunch of legalese in a document parked somewhere on a website, whether it's prominently linked to or not, doesn't really solve the problem or make sure that people understand what's being done with their data. Evan, did you like this one?
I did. First of all, what a bold thing for the president of trustee to say, given the fact that their business model has been built up over the last, maybe 15 years on, validating privacy policies. And we were talking about the EU safe harbor stuff last show. Trustee is really busy making sure that companies are properly join the EU safe harbor and all of that stuff. But, it really makes a lot of sense, what they're saying here. Because, first of all, I've always been a little bit uncertain as to how we're supposed to really appropriately think about the legal significance of privacy policies. I challenge any of you in this conversation to name a reported decision where the issue in the case was, construing or interpreting the terms of a website privacy policy. Can you name one?
Nope.
Absolutely not.
You, Eric?
No.
Yeah.
Wait, am I? Okay, I was just making sure I was still in the conversation. Things were freezing up there. So, what is the real legal significance of them? As best as I can tell, and the way that I advise clients when we're drafting privacy policies and thinking about these things from a risk management point of view, is they really are just an opportunity to inform your set of users, those who are going to be coming to your site and sharing their information with you, or even just browsing there if you're going to be using cookies or whatever. And other than that, they really are just opportunities for you to experience pitfalls, either violating the California statute, which really is the de facto federal standard because it defines all the things that you got to have in a website privacy policy, like the stuff you collect, who you share it with, when the policy was last updated, things like that. And then you sometimes have the FTC coming after companies for making false representations as to how they're treating user data that they collect on all these things. So I'm kind of coming to thinking about, or I am coming to this present thought about privacy policies after having thought of privacy policies for all these years as kind of lacking clear meaning or purpose under the law in the first place. So it resonates pretty well with me to hear what the president of trustee is saying here, saying that privacy policies are dead, long live privacy policies. because
well, in California at any rate, because we've got that pesky little law.
That's right. Yeah. Who, all of us in all the other states are worried about that same law, even though we're not there, but we have customers there. Right. And so it makes just so much more sense to conceptualize the issue that purportedly has been addressed by privacy policies all these years, informing the user base as to how this information is being used. The way that she's suggesting we talk about it is, just-in-time notifications, and this it fits in well with some of the other things a motif that we've been addressing for the last few weeks, and which are in some of our discussion points for today about. Sharing information cross-platform. Are you going to, use OAuth to allow a third-party application to use your Twitter credentials and potentially write to your Twitter account? Are you going to make this trade-off of disclosing your personal information and access to your personal information for, whatever the situation may be, a piece of cake? So that is really where the concern over individual user privacy about the stuff they're doing on the web needs to be. So it's a welcome kind of call to awareness in my book.
Right. So Evan's alluding to what I put in as sort of the companion resource to Marshall Kirkpatrick's post here on privacy policies being dead. And it's by Zach Holman and has the greatest headline ever. OAuth will murder your children. And he does a little dramatic performance piece, I would say, in text about, you getting one of those little sign-in windows an application would like to connect to your account. You're using Twitter as your OAuth provider to give your information to a third party. And the little dialogue window that pops up that you just always click allow on because you're trying to use that service and, don't want to let things stand in your way, also asks, do you want to allow the application here? He's using a Kanye analysis app. Do you want to allow that application to murder your children? Deny or allow? And of course, you're just clicking through allow. And so,
but you might be Kanye West. Who knows? I'm about to find out.
That's right. So the point being that there is some tension if you're going to try and allow this to be just-in-time notifications. You have to be confident that those notifications are actually going to get across, what they should be getting across, and you're going to have to trust the world of application developers to do that. And I guess getting back to, trustee and what they traditionally have affirmed for people that, yes, we've looked at all their stuff and they are who they say they are and they're doing what they say they're going to be doing and they have policies in place that we approve of and that we think are protecting of you. That's sort of a wide open world when we're talking about apps and mobile applications and et cetera. So, Eric, what do you think? Do we need to educate people not to allow Kanye to murder their children or his related application? Or do we need to police the developers? Or neither?
Well, I want to say, first of all, that to Zach Holman, that you can't buy a new 808 drum. 808 drums are from the 80s. That's what makes them valuable now. You have to get them used. But... no, I think these are all very good ideas. I think they're all very good ideas, and reputation, I think, could be a very good way to help solve some of this. I mean, in terms of the trends, where this is kind of coming from is that companies didn't used to stick crazy things in an adhesion contract, what lawyers call adhesion contracts, a bunch of fine print that you kind of have to sign it. They throw it in front of you. If you go to the rental car company, the rental car agreement would never contain the kinds of absurd things that they put in terms of uses or privacy policies. But at the same time, we're seeing more willingness of people to fight back, as they did with Facebook. So to try to harness reputation making in a purposeful way, I think makes sense. I think that to do things on a checkmark kind of case-by-case basis, does it make sense for me to do this, to give away this information for this purpose? I think makes sense. It's a lot of good forward thinking on this. The question is do people out there in the marketplace care did they give enough of a flip to really power these things to incentivize companies to actually put this level of detail into privacy? That question, I think, is an open one. And like I said earlier, with every passing year, as more and more adults come up, people care less and less about privacy. So, and let me also say, I did look it up. I used what online databases I have at my disposal. I can find nothing in Kentucky statutes about a 6-foot limit on concealed weapons. And right, their site for it was a Times of London article, which I find dubious at best.
All right, we'll have to let Snopes and or our IRC run that one down. Okay, speaking of dubious, I have a tip of the week for you all as well, and it involves the chair of large, prestigious law firms, litigation department, Quinn Emanuel, John B. Quinn, and his Twitter account. Mr. Quinn is tweeting, and yay, applause for the tweeting chair of the litigation department. I'm following him. It's great. I think more people in his kind of role should be doing that. But the thing that got him in trouble is, and Evan, you can confirm or deny this for me, and anybody else who's worked for a big firm, that there can be kind of a locker room mentality that goes on in those firms when it comes to their defeats and victories, particularly. And a lot of cheering and backslapping and towel snapping, I would have to say, that goes along with having something good happen in a piece of litigation or for the firm economically, for that matter. And the Quinn firm was involved in some of the litigation that was underlying the Social Network movie, and had a development crop up where it looked as though they were going to have a big payoff. And Mr. Quinn went ahead and tweeted something about that. I think the actual tweet has been deleted at this point, but said, the Winklevoss twins are shut out and big Quinn payday coming. And I just wanted to toss that out there. I guess my tip, to put a tip on this, is don't gloat via your Twitter account. If you are someone who is an executive with a company or a chairperson of a large department of a prestigious international law firm, gloating on Twitter is just bad form. I'm sorry. What do you think, Evan? Please jump in, Matt.
I was going to say, there's an old sports cliche or saying that says, act like you've been there before.
Yeah.
So I think it's, it's just potentially detrimental to your client anytime you're angering a judge or the court. So,
right.
Act like you've been there before.
Right. Well, it wound up being detrimental to the client here because, he was slapped on the wrist by the judge in the case who, the actual award that was the subject of the gloating twit was not supposed to be publicly known. So the judge was not real happy that this had happened. Evan, thoughts here?
Yeah, as legal counsel, we've always got to be keeping our egos in check. One of the reasons that lawyers have such a negative perception, or why people perceive lawyers so negatively, is because of this purported egoism and this locker room mentality, the stuff that's underlying that. So this does really give a good object lesson for civility in general, not just the responsible use of social media, but the way that the responsible use of social media is part of your overall civility plan for your life. And it's a difficult thing to do, no matter what line of work you're in. But with the practice of law, it is by nature adversarial. Attorneys spend so much of their time focused on a goal that has, a pivotal point in time where there is an outcome, and good lawyers take their work very seriously and want to do the best for themselves, do the best for their clients, have the best possible outcome. So it's an enormous psychological challenge, whether you're representing the brothers Winklevi or whether you're just representing somebody in a traffic ticket matter. It's an enormous challenge to maintain this composure. It comes with maturity that you would expect from the chairman of the litigation department a very successful law firm like what we have in this story. But it's just a wonderful object lesson for the ways that the legal profession can members of the legal profession can govern themselves to disabuse folks from having this widely held negative stereotype of attorneys.
That's right. Who needs WikiLeaks, Eric? We've got tweeting litigation department chairs telling you what's really going on.
Quinn Emanuel is a different kind of, you're talking about the possibility of a locker room mentality developing within a law firm. Quinn Emanuel is kind of the whole firm's a locker room. I mean, that's, those guys they're kind of loud guys with really outsized personalities. I interviewed for a summer clerking position with them in law school.
Former Stanford Law School Dean Kathleen Sullivan, neither a guy nor an athlete, was there practicing appellate law.
Yeah, they offered me a summer associate position and took me into one of the name partners' offices. And the guy was like, "I'm going to pay you $10,000 right now if you sign up," which my expensive private law school with my my financial aid, I would have had to end up giving it all back. So it really didn't mean anything to me, bottom line. But that's their kind of big, outsized. They're loud. I mean, they're a fantastic law firm. It's the kind of, they seem like they got a kind of David E. Kelly kind of vibe going on, despite the fact that they, are top line with top of the line clients and top of the line fee structure. But it's not particularly surprising that this comes out of Quinn Emanuel.
All right.
But not a way to treat ex-clients. Not, clearly, but.
Yes. No personal experience with the firm, only via reputation and having been opposite them from time to time. I think we actually at one point were co-counsel with them too, and I do remember an exuberance being sort of the hallmark of
it's
my
a very good way to put it
with them. Yes, an effervescence, if you will. Hey, Mick in IRC made such a nice comment that I'm just going to cap off the show with it. He asked me to pass it on to the guests, so I am doing so. He says, "Thanks so much for providing this show on the TWiT network. I think it's the highest caliber show available anywhere today. Woo!" He says, "We certainly appreciate it. We appreciate you so much, Mick, and everyone in IRC and everyone who is listening and watching, whatever your means of doing so. And along those lines, please, everyone, go to the twit.tv website. I know there's a short URL for this, but I'm not sure what it is. So just go to twit.tv, and at the top, there's a banner that is for an audience survey. Maybe Burke will say it in my ear what the short URL is. And I've taken it since I'm a listener to so many of our TWiT shows, and I guess by osmosis I listen to this one. And what it's going to ask you is where you consume TWiL and the other TWiT shows that you might listen to, in what way. And here it is. It's PodTrack. Oh, no, that's the whole long URL. I was trying to give them something short. So just go to the TWiT page and click the banner. Burke's still working on the short one. And it'll take you just a couple minutes to fill out, and it's our way of showing our advertisers in Horton Hears the Who's kind of fashion. We are here, or you are here, actually, you, the listeners. It helps us know how we can best deliver our content to you. It helps our advertisers know who's listening to what. And we'd really appreciate getting your feedback there. So as we appreciate your listening to the show, however and whenever you do. And if you are enjoying the show and you're not a regular listener, you can catch it every Friday at 11 o'clock Pacific, 1900 UTC. That makes it 1 o'clock Central and 2 o'clock Eastern. We record right here live at live.twit.tv. You can play along in the video version, or you can, of course, download the audio and video via iTunes, and we're on YouTube after we record in high-definition video. If you've got a Roku box, we've got a channel there. That's a fun way to get to all the TWiT shows. And we really, really appreciate you supporting us and our sponsors. And I really, really appreciate all of you taking the time, panelists, to be on the show with me today. Eric, pleasure having you back.
Super fun. Loved it.
super fun here as well. So stay warm.
Will
North
do.
Dakota, I just can't imagine. Are you guys getting any kind of a break or just in the thick of it still?
Yeah, it was 32 degrees yesterday.
Woohoo!
There was slush on the roads. It was crazy. It was a great
You were
day to
running around
sled.
in your shorts.
Yeah, could have.
Shorts and
Except
flip-flops.
I'm a law professor, and it just doesn't look very professorial. No student wants to see that.
Until you get a tan.
TMI. All right. Well, we
Not
really
even that.
yes. So we know folks can find you at ericejohnson.com. Where can they find you on Twitter?
I'm prepared this time, Denise.
Oh, look at you.
Tweet Law Tweets.
Wow.
Beautiful. And what are you tweeting at Tweet Law Tweets? Are those your individual tweets? Are you aggregating something?
I'm tweeting about the law of tweets and Twitter, and then I have Eric_E_Johnson, my personal tweets, and
Wonderful.
then and there's my blog too.
Perfect.
Gotta love recursion.
Yes.
Self promotion and recursion. That's what I stand for.
We've got the lower third and the upper third for you. So thank you so much, Eric. Matt, great pleasure having you back on the show. Thank you for all your insights.
No, I love it. Anytime. And by the way, it's also, I don't know, windows open. It's probably 72, 73 degrees out here. So
Great. Where are you again?
And I'm in Phoenix.
In Phoenix, Arizona. Delightful.
Yeah.
And that's why your Twitter handle is IMACAZ. Folks can
I was
follow
going
you
to
there.
say that's my last time I was on. I had a different Twitter handle that was confusing to me, so I switched it up.
All right, and folks can find you at that's SUMIPlaw.com.
Yep, that's it.
Great. Have a wonderful weekend. Thanks for joining us.
You too. Thanks.
And Evan, are we going to go out with a Monty Python quote? Please, please, please.
Geez. I am Spartacus. Well, that's I got so distracted. I went away. Maybe just one tiny breath mint. Let's table it. I'll be.
We'll
be
bravely take to our feet, beat a brave retreat, and follow Sir Robin out of here. How about that?
Yes.
All right, and before you do that, though, go find Evan at internetcases.com, and he's Internet Cases on Twitter. And we will see you all next Friday on This Week in Law. Take care till then.